Welcome to today's Employment Standards General Overview presentation. Thanks for joining us. Before we begin, please be aware of our disclaimer and copyright notice. I'll give you a moment to read it. Basically, we've made every effort to give you the correct information, but if there are any discrepancies between this presentation and the Employment Standards Code, the code will prevail. Please note the copyright of this presentation belongs to the Government of Alberta. The goals for today are to provide you with a general overview of Alberta's current employment standards and to highlight some additional resources to assist you in finding more detailed information. So what are employment standards? The Employment Standards Code provides the minimum standards of employment for employers and employees in Alberta. You cannot make agreements for less than the minimum standards. There are some unique rules for different industries found in the regulation, like the way overtime hours are determined for the oil well servicing or trucking industry, or how general holidays are treated for construction employees. The Employment Standards Code also establishes the framework for program delivery and enforcement of the entitlements under the code. And while the code establishes minimum standards, an employer can choose to offer greater benefits to the employee if they so wish. Employment standard rules apply to most employees working in Alberta with a few exceptions, like those who work in federally regulated industries such as banks and air transportation. These industries often have alternate legislation defining those workers' entitlements and protections. This is our agenda for today. Record keeping requirements, wages and payment of earnings, deductions, hours of work and rest periods, overtime, vacation entitlements, general holidays and holiday pay, averaging arrangements, as well as we'll look at termination notice and pay and group termination, temporary layoffs, youth employment, job protective leaves, and program administration. And finally, we'll wrap up and review a few resources we have available for you. Record keeping requirements. A job application, a letter of offer, or an email are probably the first types of records an employer will begin to keep when hiring a new employee. Proper record keeping is not only useful, it is mandated in the legislation. This slide summarizes fundamental documents that all employers must keep for their employees. All records must be kept for a minimum of 3 years. Some categories do not apply to individuals employed as managers, supervisors, professional employees, or outside salespeople. For more information on these exceptions, visit our website or check out the regulations. The keeping of complete and comprehensive records will assist in resolving any disputes between an employer and an employee. If a complaint is brought forward, employers would be able to support their position by providing these records as evidence to an officer. If an employer does not keep records, an employment standards officer is permitted to make an assessment for outstanding earnings using any manner the officer considers appropriate. Wages. Wages are to be paid for work that has been performed. Hourly wages, salaries, or commissions are all examples of wages. The definition of wages excludes many things. Other employment standards entitlements are not wages. Overtime, vacation pay, general holiday pay, and so on should not be included in the calculation for wages. Expenses, gifts, and tips are also not wages and are not covered under entitlements in the legislation. It's important to determine accurate wages as the other categories of entitlements rely on wages for their calculation. And when wages are calculated in error, all the other earnings will be inaccurate as well. Our current standard minimum wage is $15 per hour. There is also the student minimum wage, a weekly minimum wage, and a monthly minimum wage. Head over to our website to see if these alternate minimum wages apply to you. In general, If an employee is called to work and then sent home, perhaps because there isn't enough work, then they must be paid 3 hours at the minimum wage or paid their regular wages for the time that they were there, whichever is greater. There are some exceptions to this, however, such as for school bus drivers who must be paid only 2 hours at minimum wage. Employees that are on call or standby have no requirement to be paid unless they perform work. If the employee does perform work, those hours may contribute to daily or weekly overtime. Payment of earnings. Employers must pay their employees at least once a month or use one of the following pay periods listed on the slide: daily, weekly, bi-weekly, or semi-monthly. An employee isn't considered paid until they receive the funds, and earnings must be paid within 10 days after the end of the pay period in which they were earned. Pay statements should accompany those payments. Electronic statements of earnings which were already accepted in practice are now also permitted. Electronic statements of earnings are acceptable as long as the employee has confidential access and can print a copy of the statement. Employers may choose between two time frames in which final earnings are to be forwarded to employees. Therefore, employees must receive their final pay within 10 consecutive days after the end of the pay period in which termination occurred, or 31 consecutive days after the last day of employment. Deductions. Employers can deduct overpayments without an employee's written consent for the following: overpayments resulting from a payroll calculation error that occurred within 6 months prior to the deduction, and vacation pay paid to the employee prior to it being earned. Employers must provide advance written notice that the deduction will occur to the affected employee. If an employer notices in their records today that there was an overpayment or error that happened 8 months ago, this being beyond the 6 month limitation, the employer could still make that adjustment as long as they have the employee's written consent. It's important for employers and employees to be reviewing their records and pay statements often enough to catch any concerns before too much time passes. When it comes to deductions, employers may generally only deduct from an employee's earnings amounts that are permitted by an act, judgment, court order, authorization by a collective agreement binding on the employee, or authorized in writing by the employee. This is except for payroll overpayments or vacation payment errors mentioned in the previous slide. Note that employees cannot personally authorize deductions, and employers cannot deduct for faulty workmanship, which includes accidental damage to an employer's vehicle or equipment; cash shortages where more than one employee had access to the cash; or cash shortages resulting from a failure to collect all or any part of the purchase price from a purchaser; breakage in a restaurant and mistakes in production; uniforms or special articles of apparel the employee is required to wear during their work hours. In other words, an employee cannot be requested nor required to sign an authorization to keep their job. If an employee does end up signing on a prohibited deduction, an employer is still not permitted to make that deduction. For example, if a server has a table dine and dash on them, they cannot sign an authorization to deduct that bill from their earnings. Or if an employee has an accident where the company vehicle is damaged, they cannot be required to pay for those damages from their earnings either. Please note, personal protective equipment, or PPE, is not considered a part of a worker's uniform under employment standards. For questions regarding PPE requirements, please contact Occupational Health and Safety toll free at 1-866 415 8690. Hours of work and rest periods. The code requires that hours of work do not exceed 12 hours in any one day unless an accident occurs, urgent work is necessary, or other unforeseeable or unpreventable circumstances occur. In those cases, the hours of work will increase only to the extent necessary as a means of avoiding serious interference with business operations and the safety of the individuals working there. Some industries, like road building or heavy construction, have an exemption to the 12-hour rule. Any exemptions are set out in the Employment Standards Regulation. Employers may apply for a variance to authorize extended hours of work. Please note that this rule is also called hours of work confined. This means that if someone starts their shift at 7 a.m., they should normally not be scheduled to work past 7 p.m., even if they were not actively working within those 12 hours. Meaning split shifts, for example, are still subject to hours of work confined. When a meeting or training is scheduled on a day off, employees who attend must be paid for the time, and those hours can contribute to overtime. As an example, if there's an 8-hour CPR training for staff on a Saturday, when employees normally work a 40-hour week from Monday to Friday, then the entitlement for each employee attending that training would be as follows. They should be paid at least 4 hours of pay at a rate of minimum wage or higher for those hours, plus 4 hours overtime pay. To compare, if a meeting occurs for 2 hours, say from 5 until 7 p.m., then several scenarios can apply. If the employee worked all day and had to stay, overtime may be applicable if this results in working more than 8 hours that day, or those additional hours result in exceeding 44 hours in the work week. If the employee was called in for the meeting, they could either be paid 2 hours at the regular rate of pay or the 3-hour minimum wage rule applies, whichever of the two is greater. Please also note that training must be paid if it occurs after employment starts. This includes situations where a new employee job shadows an existing employee. An employee performing such work is entitled to the payment of wages. Let's review employment standard rules for travel time. Generally, the time spent commuting to and from the work site is not considered time spent working. Travel time is work when employees go from one job site to another, or if they have to pick up materials or perform tasks on the way to or from work. As an example, Dan wakes up in the morning and drives to the shop. This is not work time. He then takes the company truck to pick up materials. This is work time. Dan goes to the job site and drops the materials off. This is work time. He returns to the shop, and this is still considered work time. Before leaving for the day, Dan is directed to take home the company truck so that he can pick up more materials the next morning to bring to the job site. Dan leaves the shop to go home. This is not work time, but when Dan wakes up the next day and leaves home to go pick up the materials, that is considered work time. As for rate of pay, travel time that occurs after the time the employee started to provide services must be recorded as hours of work. Travel time may be paid out at a different rate, as long as the employee is informed ahead of time and the rate is at least the minimum wage. Employees that work shifts for 5 hours or less will not be entitled to a break. If employees work more than 5 hours but less than 10, they are entitled to one 30-minute break. And if employees work 10 hours or more, they are entitled to at least two 30-minute breaks. If both parties agree, they can split the 30-minute break into two 15-minute breaks. There are specific rules regarding when breaks are provided if the employer and employee cannot agree on a rest period schedule. Should they not agree on a rest period schedule, the employer must provide at least 30 minutes within or immediately following the first 5 hours of the shift at a time chosen by the employer. If the shift is more than 10 hours, the employer must provide a second rest period of at least 30 minutes after the first 5 hours of the shift. Exceptions to this rule would be if one of the following occurs. An accident occurs or urgent work is required, other unforeseeable or unpreventable circumstances, different break arrangements have been made through a collective agreement, or it is not reasonable for the employee to take a rest period. If the employee is unable to take their break, then that break must be paid. Many employees receive 2 days off every week. However, the minimum required for rest is 1 day off in each work week, and a work week is considered to be 7 consecutive days. As you can see on the chart on the slide, the number of work weeks and required rest days can be combined. Employees must receive at least 1 day of rest in each consecutive work week, or 2 consecutive days off in 2 consecutive weeks, and so on. However, if an employee has worked 24 straight days, they must receive 4 consecutive days off, unless a variance or exemption has been granted. Overtime. When it comes to overtime, most employees are entitled to overtime pay at 1.5 times their wage rate for any hours worked over 8 hours in a day or 44 hours in a week, whichever is greater. This is known as the 844 rule. Banking time is permitted with a banked overtime agreement. Overtime is banked at a rate of 1 banked hour for each overtime hour. Banked overtime could sit for 6 months from when it is earned. If it is not used, it is paid out at the 1.5 times the wage rate. The regulation outlines which industries and occupation the 844 rule does not apply to. For example, there are alternate overtime rules for certain industries like trucking, which is anything over 10 hours per day or 50 hours per week. Managers and certain professionals like engineers, accountants, and insurance agents are not entitled to overtime. As stated previously, all overtime must be paid at a rate of at least 1.5 times the regular rate of pay, or bank time off is given at a rate of 1 hour banked for 1 hour of overtime as part of an overtime agreement. Salaried employees are treated no differently than employees paid in any other manner when calculating overtime hours. The salary is considered to cover payment only for the regular hours of work. Overtime hours must be compensated in addition to the regular hours worked. When an employee takes bank time off, those hours and the subsequent payment are considered wages. These wages are to be considered when calculating vacation pay and general holiday pay entitlements. Please note that some employees and industries aren't eligible for overtime hours and overtime pay. To learn more about the industries who are exempt or have different overtime rules, please visit the Employment Standards website. Vacation entitlement. Vacation consists of two components, vacation time and vacation pay, and those components can happen at different times. The first component is time off for vacation. Employees should be provided vacation time within 12 months of the time that it was earned. Vacation days can be provided in one unbroken period, or if an employee requests in writing, vacation can be taken in two or more periods as long as each vacation is at least a half day long. A reminder that these are the minimum amounts. There are many employers who offer a greater amount of vacation entitlement in the first few years. Sometimes an employer may wish to establish a common anniversary date for employees to take vacation. If a common anniversary date is established, the employee must not lose any of their entitlements as a result of the date imposed. Vacation entitlements have not changed, as you can see on the table. However, clarification was added regarding vacation entitlements for an employee who utilizes a protective leave. For example, personal and family responsibility leave to care for yourself or compassionate care leave to care for a loved one. An employee Unprotected leave, as provided in the Employment Standards Code, continues to accrue length of service with their employer, therefore affecting their vacation entitlement. General holidays and holiday pay. Alberta has 9 general holidays, which are shown on the slide. General holidays are commonly observed days of rest, sometimes called statutory holidays. There are specific requirements to be met for employees to receive a paid day off for these holidays. And we'll go through the eligibility requirements in the next slide. Now we are looking at general holiday pay eligibility. There are a few eligibility steps for entitlement, and we'll talk mainly about entitlement to average daily wage. First, an employee must have worked at least 30 workdays in the previous 12 months with the same employer. Second, employees must meet what is known as the 5 of 9 rule. This rule helps to determine if the day of the week that the general holiday fell on was a regular workday for the employee. If an employee has an irregular schedule, but has worked at least 5 of the previous 9 Mondays before Labor Day, for example, which always falls on a Monday, then Monday is considered that employee's regular day of work, and they have met another step for eligibility for average daily wage. If an employee has an irregular schedule and has not worked the last 5 of the previous 9 Mondays, then Monday is not their regular day of work, and they have missed a step for eligibility. But if they work on this holiday, they may still be eligible for 1.5 times their wage rate for all hours worked on that day. Third, the employee must not be absent without consent for the general holiday itself or the shift immediately before and immediately after the general holiday. Here are the two options an employer may choose to calculate average daily wage. By dividing the total wages earned in the 4 weeks immediately preceding the general holiday by the number of days worked, or by dividing the total wages earned in the 4 weeks ending on the last day of the pay period immediately preceding the general holiday by the number of days worked in the same period of time. As with other rules, there are some exceptions and exemptions for general holiday pay. For additional details, please visit the Employment Standards website. Averaging arrangements. Averaging arrangements allow employers to average an employee's hours of work over a period of 1 to 52 weeks for the purpose of determining the employee's entitlement to overtime pay or time off with pay. An employer must give at least 2 weeks written notice of a requirement to work an averaging arrangement to each employee it applies to, unless the employer and employee agree to a different notice period. An employer is not required to provide 2 weeks written notice to a new employee if written notice was given to the employee before employment began. Employers must, before the arrangement starts, provide a written copy of the averaging arrangement to each employee to whom the averaging arrangement applies, and in the case of an averaging arrangement that applies to a group of employees, post the averaging arrangement on the employer's internal website, if any, and in one or more conspicuous places in the workplace where it may be viewed by the employees to whom the averaging arrangement applies. Employers may also cancel and replace an averaging arrangement by providing 2 weeks notice. Employees are not able to cancel an arrangement. Only the employer may do so. There is no maximum term for averaging arrangements. This means the arrangements do not expire and do not have to be renewed. The arrangement must specify the daily and weekly scheduled hours for the averaging period. Employers should provide 24 hours advance notice of a shift change unless an accident occurs, urgent work is necessary, unforeseeable circumstances arise, or an employer specifies different notice provisions in the arrangement. An employer may specify in an arrangement that the daily overtime does not apply, or another daily overtime threshold applies in averaging arrangements where daily overtime applies. In these circumstances, daily overtime would be over 8 hours per day if they were scheduled for less than 8 hours, or over the daily scheduled hours if more than 8 hours were scheduled, or when the daily overtime threshold is included in the arrangement. Daily overtime would be determined in accordance with the arrangement. Averaging period overtime applies for all averaging arrangements, even if daily overtime is not applicable. Averaging period overtime hours are determined by reviewing the hours of work over 44 in a week for a single week schedule, or hours of work over an average of 44 hours per week in a multi-week schedule. As averaging arrangements can be very complicated, we would encourage you to review all the rules on our website or sign up for our averaging arrangement specific live webinars. Let's move on to termination notice and termination pay. The code provides rules for when termination notice is required and how to calculate termination pay. Employers exploring termination should be aware of the specific provisions for when employment is terminated by an employer. The employer has three options to terminate the employment of an employee. They can provide notice, pay in lieu of notice, or a combination of both. When termination notice is required, the number of weeks of written notice increases as the employee's years of service increase. And we'll give you a moment to take a look at the timeframes on the screen. There are many situations where termination notice or pay in lieu of notice is not required. The most common of these is for just cause, as well as seasonal workers, employees who are within 90 calendar days of employment, specific workers in the construction industry, and when unforeseeable or unpreventable circumstances exist and beyond the control of the employer. If disputes arise regarding termination pay entitlements, the employer is required to provide evidence and support of their position that termination pay was not required. Employment standards will evaluate each situation on a case-by-case basis. Next, we'll discuss group termination requirements. Employers who terminate 50 or more employees from a single location are required to provide 4 weeks advance notice to the Minister of Jobs, Economy, and Trade. Employers are still required to review an employee's individual eligibility for termination notice. Temporary layoffs. When an employer wishes to maintain an employment relationship without terminating an employee, they may consider a temporary layoff. The maximum layoff period for layoffs is 90 days within a 120-day period. Employers need to provide written notice to employees of a temporary layoff prior to the layoff commencing. If the layoff is a result of unforeseeable circumstances, the employer needs to provide as much notice as possible, and this will be evaluated on a case-by-case basis. For employment standards to consider the temporary layoff notice to be valid, it must be in writing, state that it is a temporary layoff notice and its effective date, and include sections 62 through 64 of the Employment Standards Code. Employers may recall an employee on temporary layoff to work by providing the employee with recall notice. Notice must be in writing, served on the employee, and state that the employee must return to work within 7 days of the date the notice was served on them. Employers can use the methods of service outlined in the ES regulation, section 63.1, including registered mail or personally on an employee. Service is required as the employer must demonstrate that the employee did in fact receive their notice to return to work. An employee who fails to return to work within 7 days of being served the recall notice will have forfeited their rights to their job and termination pay if the employer decided to terminate them because the employee failed to return. Now let's take a look at youth employment. The job creation student wage only applies to students enrolled in an educational institution and does not apply to youth who are out of school. Next, let's look at when the student wage applies. Once it is determined that a worker is eligible for the job creation student wage, that being a student under 18, the next variable to look at is whether school is in session or if they are working during a school break. When school is in session, the 28-hour threshold applies. This means for the first 28 hours per week, a student receives $13 per hour. Starting with the hour 29 and up, they receive $15 for those extra hours. The first 28 hours are always at the $13 per hour rate. When a student under 18 is working on a school break, there is no threshold. The rate is always $13 for all hours worked. School break times may vary from school to school, and school breaks include summer vacation, Christmas and winter holidays, and spring break. Note, these rules only apply to students under 18. If the worker is not a student or is over 18, they receive the regular minimum wage, which is $15 per hour. There are many other rules surrounding youth employment depending on age, including when an employee may work, what kind of work can be performed, if parental or guardian consent or a permit is needed. Please visit the youth employment section on our website to learn more about the rules that apply to youth. We'll now go over which leaves are available and who is eligible to take job protective leaves. Job protective leaves entitle employees to time off without pay to attend to specific types of personal or family matters. Job protective leaves are unpaid, though the employer always has the option to pay an employee during the leave. For many leaves, employees may be required to have been employed with their employer for at least 90 days and are often required to provide their employer with some type of notice or documentation prior to starting the leave and/or returning back to work. Here are the short-term leaves available. In general, employees are not required to provide any medical notes or other documentation to utilize these leaves. However, the employee must provide as much notice as reasonable given the circumstances to take the leave. Now let's review our regular leaves that are of a longer term. I'll give you a few moments to read about these. A medical certificate issued by a physician or nurse practitioner is required for long-term illness and injury leave, critical illness leave, and compassionate care leave. In some situations, a medical certificate may be required for maternity or parental leave. The short-term and long-term leaves reset each calendar year except the citizenship ceremony leave, which can only be used once for a person's own citizenship ceremony. So let's take a brief look at administration of the Employment Standards Program. Here's an overview of our complaint resolution process. Where employment disputes arise and the parties are unable to resolve the matter on their own, the Code provides a complaint resolution mechanism that includes mediation, investigation, enforcement, and appeal provisions. Here are different ways that a complaint may be resolved, and I'll give you a few moments to read this slide. As you can see, when a complaint reaches our office, there are many options for resolution and conclusion. Let's wrap up today's session. We've covered record-keeping requirements, wages and payment of earnings, deductions, hours of work and rest periods, overtime, vacation entitlements, general holidays and holiday pay, averaging arrangements, termination notice and termination pay, temporary layoffs, youth employment, job protective leaves, and program administration. That's a lot of information, so we'd like to remind you that there is a recording of this session on our website for you to listen and learn. We have a number of resources for you to find more information. Please remember to visit our website. The full link is shown here for your reference. There you'll discover e-learning tools, find recorded webinars, and learn about upcoming dates of future live webinars. Please remember the King's printer is responsible for providing copies of the Employment Standards Code and regulation. Remember that if you need to make a complaint, you can go to our website with the web address on your screen. If you want to contact us or ask a question, please use our contact page listed on the slide. Additionally, you can utilize our contact center toll-free at 1-877-427-3731. And if you want to make an anonymous tip with employment standards, the link is also provided on the slide. Thank you for viewing today's Employment Standards General Overview session, and we hope that you have a pleasant day.